6-7 यूनिट जो है ये यूजीसी नेट जेआरएफ में जिनका भी मतलब सब्जेक्ट पॉलिटिक्स है, तो ये इंडियन कॉन्स्टिट्यूशन वगैरह इस चीज़ को हम बड़े ही हल्के में लेते हैं और सोचते हैं कि ये सारी चीज़ें तो हमने पढ़ी रखी है, इसमें क्या मतलब डिफ़िकल्टी है। बट मेक श्योर कि यू आर रिवाइजिंग ऑल द थिंग्स अगेन एंड अगेन, क्योंकि ये सारी चीज़ें पढ़ने के बाद भी हम भूल जाते हैं, ठीक है। तो सबसे पहले हम डिस्कस कर लेते हैं एक बार फीचर्स ऑफ इंडियन कॉन्स्टिट्यूशन। सो जो इंपॉर्टेंट फीचर्स है ना इंडियन कॉन्स्टिट्यूशन की, द कॉन्स्टिट्यूशन ऑफ इंडिया प्रोवाइड्स फॉर अ फेडरल सिस्टम ऑफ द गवर्नमेंट। आर्टिकल नंबर 1 ऑफ द कॉन्स्टिट्यूशन डिस्क्राइब्स इंडिया एज द यूनियन ऑफ स्टेट्स, कि ये यूनियन है स्टेट्स का क्या है, यूनियन है। Federalism is a system of government in which all the administrative powers are divided between the central and the state governments by the constitution, and state governments are not agents for the central government, nor do they draw their authority from it. On the other hand, both the central and state governments draw their authority from the constitution, and the original constitution is a written document containing 395 articles and 8 schedules. The Supreme Court of India, which is the apex court in India, acts as the custodian of the constitution. You know this thing. All the powers have been divided into 3 lists. The union list 99 items, the state list 66 items, and the concurrent list 47 items. In case of clash between the central and state laws, the former prevails, and the residuary powers have been vested by the constitution in the central government, and the constitution of India stands at the top of the hierarchy of all the laws, both central and state. समझ गए? आगे जो है वो है नॉन फेडरल और यूनिटरी फीचर्स। ये क्या है? In the division of powers, 99 items have been included in the union list, while the state list contains only 66 items. Both the center and the states have power to legislate, but the central government enjoys an overriding position, and the state in India have not been given any right to make or unmake their own constitution, and the framers provided a single common and unified constitution both for the center and the states. And the Indian constitution creates a single citizenship of India, which is common to all the people of various states and the union territories. And the union constitution accords a representation to the various states in the Rajya Sabha on the basis of their population. And during the proclamation of emergency, the parliament gets the power to legislate for the whole or any part of the territory of India. Under the Indian constitution, the governors, who are the administrative heads of the state administration, are appointed by the president and holds office during his pleasure. ठीक है। उसके बाद इन इंडियन कॉन्स्टिट्यूशन देयर इज द प्रोविजन ऑफ कॉमन ऑल इंडिया सर्विसेज लाइक IAS, IPS, etc. एंड द मेंबर्स ऑफ दीज सर्विसेज आर अपॉइंटेड बाय द प्रेसिडेंट ऑफ इंडिया ऑन द रिकमेंडेशंस ऑफ द यूनियन पब्लिक सर्विस कमीशन, एंड द जजेस ऑफ द हाई कोर्ट्स आर आल्सो इंडिपेंडेंट ऑफ द स्टेट्स व्हिच डू नॉट possess any power with regard to their appointment, removal and service condition, and they are appointed by the president and can be removed by him. And now schedules of the Indian constitution. So first schedule क्या कहता है? It belongs to the list of the states and the union territories, and there are 28 states and 7 union territories. Second schedule deals with the salaries and allowances of the president, vice president, chief justices of Supreme Court, High Court, and the speaker of the Lok Sabha, comptroller and auditor and general of India, etc. Third schedule deals with the form of the oaths or affirmation, and fourth schedule it deals with the allocation of seats for each state of the India in the Rajya Sabha. Fifth schedule deals with the administration and control of the scheduled areas and scheduled tribes, and sixth schedule it deals with the provision of administration of tribal areas in Assam, Meghalaya, Tripura, Mizoram, and Arunachal Pradesh. Seventh schedule deals with the allocation of powers and functions between union and states. It contains 3 lists: union list, state list, and concurrent list. Eighth schedule, it contains 22 languages of India recognized by the constitution, and these are listed below: Assamese, Bengali, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Malayalam, Manipuri, and Marathi and Nepali, Odia, Punjabi, Sanskrit, Sindhi, Telugu, Tamil, Urdu, Bodo, Dogri, and Santhali, Maithili, etc. Ninth schedule has been added by the first amendment in 1951. It contains acts and orders related to the land tenure, road taxes, railways and industries. 10th schedule, it has been added by the 52nd amendment in 1985. It contains provisions for the disqualification of the members of the parliament and state legislature on the ground of defection. 11th schedule has been added by the 73rd amendment act 1992. It contains some list of subjects on which schemes may be entrusted to the panchayats by the legislative assembly of a state for the implementation Panchayati Raj. 12th schedule, it has been added by the 74th amendment act 1992. It contains the list of subjects on which schemes may be entrusted to municipalities by the legislative assemblies of the state of the implementation. States and union territories. States and union territories की बात करें तो जो पार्ट 1 है, फर्स्ट शेड्यूल आर्टिकल नंबर 1 to 4 ऑफ द कॉन्स्टिट्यूशन डील्स विद द यूनियन एंड इट्स टेरिटरी. आर्टिकल नंबर 1 ऑफ द कॉन्स्टिट्यूशन सेज इंडिया, दैट इज भारत, शैल बी अ यूनियन ऑफ स्टेट्स. आर्टिकल नंबर 3 deals with the formation of the new states out of the territory of the existing states. Reorganization of the states with the dexterous efforts of the Sardar Vallabhbhai Patel. The princely states and British Indian provinces were merged, but the demand to formulate new states on the linguistic basis gained currency with the culminated into the creation of Andhra Pradesh on October 1, 1953. Later on, Fazal Ali Commission's recommendation led to the formation of the State Reorganization Act 1956. It created 14 states and 6 union territories. Special status to the Jammu and Kashmir. The Indian Constitution accords special status to the state of Jammu and Kashmir. Article number 1 of the Indian Constitution refers Jammu and Kashmir as the part of the territory of India as 15th state. Under Article 370, the power of the Parliament to make laws for the state shall be limited to those matter in the union and concurrent list which are in concurrence with the government of the state. A separate constitution was created for the Jammu and Kashmir by a constituent assembly appointed by the state and came into force from the January 26, 1957. Citizenship, fundamental rights and duties and directive principles. Citizenship part 2, article number 5 to 11 contains provisions relating to the citizenship of India. And the Constitution of India provides for a single citizenship for the whole of India, and the provisions for opting Indian citizenship are as follows. Domicile. A person domiciled in India at the commencement of the Constitution of India is a citizen of India, provided he was born in India, either of his parents was born in India. He has ordinarily been resident in the India for the last 5 years immediately preceding the commencement of the Constitution. Residents in the foreign countries, any person ordinarily residing out of India is deemed to be a citizen of India if he or either of his parents or any of his grandparents was born in the pre-partition India, provided that he is registered as a citizen by a diplomatic or consular representative of India. Acquisition of citizenship. According to the Citizenship Act 1955, the citizenship could be acquired through any of the following 5 methods by birth. All the persons born in India on or after 26 January 1950 are treated as citizens by the birth. By descent, a person born even outside India shall be treated as citizen of India by descent if at the time of his birth his father is a citizen of India. Loss of citizenship. The Citizenship Act envisages the following 3 methods for the loss of the Indian citizenship: by renunciation, by termination, and by deprivation. It is noteworthy that the citizenship of a person can be taken from him only if he has acquired Indian citizenship by naturalization, pure domicile, or registration. Persons who are citizens of India by birth or descent cannot be deprived of their citizenship in any of the above manners. Fundamental rights. Part 3, article number 12 to 35 of the Constitution dealing with the fundamental rights constitutes the Magna Carta of the essential freedoms of the Indian people, and these rights are justiciable and can be enforced by courts if necessary. Originally these were 7, but in 1979 through 44th Amendment Act, the right to property was removed, and right to equality, article number 14 to 18, right to freedom, article number 19 to 22, right against exploitation, article number 23 to 24, right to freedom of religion, article number 25 to 28, cultural and educational rights, article number 29 to 30, right to constitutional remedies, article number 32, and this article provides for the enforcement of the above rights through the judicial writs of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Habeas corpus, it is issued against wrongful detention, and the detained person is released after the innocence is proved, and this cannot be issued in the case of the criminal offences. Mandamus, it is issued to lower court, tribunal, or a public official to perform his duties through which fundamental rights of a person are enforced. Prohibition, it forbids a lower court to perform an act which is outside its jurisdiction. Quo warranto, it restrains a person from acting in the public office to which he is not entitled, and certiorari, it is issued when a court or tribunal acts beyond its jurisdiction. It differs from prohibition in that it is issued after the act is performed. Fundamental duties. 10 fundamental duties were incorporated in the Constitution under article 51 ka part A through the 42nd Amendment in 1976, and these are following: to abide by the Constitution and respect its ideals and the institutions, the national flag and the national anthem, and to cherish and follow the noble ideals which inspired our national struggle for freedom, and to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render national service when called upon to do so, and to promote harmony and the spirit of the common brotherhood against all the people of India, transcending religious, linguistic, and religional or sectional diversities, to renounce practices derogatory to the dignity of women, and to value and preserve the rich heritage of our composite culture, and to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures, and to develop the scientific temper, humanism, and the spirit of inquiry and reform, and to safeguard public property, and to abjure violence, to strive towards the excellence in all the sphere of the individual and collective activities, so that the nation constantly rises to higher levels of the endure and achievements, to provide primary education to children as a social responsibility by 86th constitutional amendment. And directive principle of state policy की बात करें तो part 4 article 36 to 51 deals with the provisions of the directive principles with the aim of the ensuring a just and equitable socio-economic order welfare state, and these are not enforceable by the court. Article number 39 to provide educate means of the livelihood for all the citizens to secure equal pay for the equal work for men as well as women. And article number 40 makes its duty of the state to organize a village panchayat as unit of the self-governance. And article 43 stands for the right to living wage and decent standards to life. It also secures workers' right to participate in the management of industries. Article number 44 enjoins upon the state to secure a uniform civil code for the citizens. Article 45 stands for the providing free and compulsory primary education. Article 46 gives emphasis on promoting educational and economic interests to weaker sections and protecting them from the social injustice. Article 47 holds that the state shall endeavour to raise the level of nutrition and standard of living and to improve public health. Article 49 to protect all the monuments of the historic interest, the national importance. Article 50 enjoins upon the state the duty to separate judiciary from the executive. Article number 51 the state shall endeavour to promote international peace and amity. And then उसके बाद जो next है वो ये है यहाँ पे the president holds office for a period of 5 years from the day on which he enters upon his office. He is eligible for re-election, and the president takes oath in the presence of the Chief Justice of India or in his absence senior most judge of the Supreme Court. He can submit his resignation to the vice president. And qualification for the election of the president: he must be a citizen of India, he must have completed the age to 35 years, he must be qualified for the election as a member of the Lok Sabha, he must not hold any office or profit under the government of India or the government of any state or under any local authority subject to the control of any of these governments. Election of the president: the president is elected by the member of an electoral college consisting of the elected member or to the both the houses of the parliament and the elected members of the legislative assemblies of the states. The nominated members of both the houses of the parliament, the nominated members of the states legislative assemblies, and the members of the state legislature council do not participate in the election of the president. And the president's elections held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. The value of vote of an MLA and MP is such that a true federal character of the office of the president is maintained by striking a balance between the state and the center. Value of the vote of an MLA: population of the state by my total elected members 1000 of this the population of the state, total elected members of the state legislative 1000. And value of the vote of an MP is equal to value of vote of total MLAs of the states and the union territories by my total elected members of the parliament Lok Sabha plus mein Rajya Sabha. Value of the vote of the MLA differs from one state to another, and to be declared elected to the office of the president, more than 50% of the valid votes are required. In case of any dispute regarding the election of the president, only the Supreme Court is authorized to intervene in the matter. उसके बाद जो next है वो है executive powers. The president is the executive head of the sovereign, socialist, secular and democratic and Republic of India. He is ex officio supreme commander of the armed forces. He can declare war and make peace. The president appoints the prime minister and the other ministers of union and the attorney general of India and the comptroller and auditor general of India, judges of the Supreme Court and high courts, and ambassadors and other diplomatic representatives, and the governor of a state or the lieutenant governor or the chief commissioner or administrative of a union territory, and chairman and members of the UPSC and joint commissioner and UPSC of the joint So we were talking कि जो है the governor of a state or the lieutenant governor or chief commissioner or the administrator of a union territory, and chairman and members of the UPSC and joint commission for a group of states, and chief election commissioner and other members of the election commission, chairman and members of the finance commission, deputy chairman and members of planning commission, a commission on official language, commissions for the scheduled castes and scheduled tribes, commissions to investigate the condition of backward classes and species, and special officer for the linguistic minorities. Legislative powers: bill passed by the parliament must receive his assent before it becomes an act, except in the case of the money bills on which his prior assent is necessary. And the president enjoys veto power, usually called pocket veto. It can be used for withholding bill for any time. Article number 111. President can issue ordinance when the parliament is not in the session. He nominates 12 members to the Rajya Sabha and 2 Anglo-Indian members to the Lok Sabha. He can address either house of the parliament. He is an integral part of the parliament but himself is not a member of the parliament. He can summon and prorogue either house of the parliament all joint sittings of both the houses when necessary. he can dissolve the Lok Sabha and other fresh elections. And financial powers की बात करें तो he causes the annual union budget and important reports to be laid before the parliament, and no money bill can be introduced in the parliament without his prior assent. And he appoints a finance commission after every 5 years for the allocation of share of proceeds of taxes between the union and the states. Judicial powers, he can grant pardon, reprieve, respite or remission of the punishment, or suspend, remit or commute the sentence, including the sentence of death. And the president is the only authority to grant pardon in case of death sentence or on the advice of the council of the ministers. He is not answerable to any court of law. Emergency power की बात करें, so the president can suspend the whole constitution or some articles of it under the emergency conditions arising out of national emergency article number 352 due to the external aggression or armed rebellion, or state emergency article 356 due to failure of the constitution machinery in the state, financial emergency article number 360 due to financial instability or crisis in any region of the country. Impeachment, removal of the president, article number 61, the president may be removed from the office by impeachment for the violation of the constitution. The impeachment procedure can be initiated in either house of the parliament, and the charge must come in the form of a proposal which must be signed by at least 1/4 of the total membership of the house, and before the resolution could be passed, 14 days notice must be given to the president. If after the notice the house passes the resolution by a majority of not less than 2/3 members of that house, the matter will be referred to the other house, and after the charges are framed by one house, the other house investigates them. If it is found true, the president stand impeached from the date on which such a motion is passed. At this time, the president has the right to defend himself either in the person or through his lawyer. और उसके बाद the vice president. Article 63 provides that there shall be vice president of India. Vice president is elected by the members of two houses of the parliament in accordance with the system of proportional representation by means of the single transferable vote. Any dispute relating to or connected with the election of the vice president is decided by the Supreme Court, whose jurisdiction is exclusive and final, and the eligibility conditions for the election of a person or as vice president are the same as those of the election as president, except that for the former the candidate must be qualified for the election as a member of the council of the state Rajya Sabha. The vice president is the ex officio chairman of the Rajya Sabha. When he discharges the functions of the president, the vice president shall not perform the duties of the office of the chairman of Rajya Sabha and shall not be entitled to receive the salary of the chairman. Prime Minister की बात करें, so the real executive authority is exercised by the prime minister and his council of ministers. The prime minister is appointed by the president. He gets the same salary as other ministers. He is the ex officio chairman of the planning commission, national developmental council, national integration council and interstate council. Powers की बात करें, so the president convenes and procures all the session of the parliament in the consultation with him. He can recommend the dissolution of the Lok Sabha. He allocates portfolios, can ask a minister to resign and can get him dismissed by the president. Councils of ministers, there are three types of council of ministers: minister of cabinet rank and minister of state, and deputy minister does not hold separate charge. And council of ministers is collectively responsible to the Lok Sabha. It is a team and its members sink or swim together. Article number 75, this is called collective responsibility. A person can remain a minister without being a member of either house up to 6 months. Union legislature, according to the Article 79, the Parliament of India consists of the President and two houses, the Rajya Sabha upper house and the Lok Sabha lower house. Rajya Sabha, the upper house of the Parliament consists of representatives of the states. The maximum strength of the Rajya Sabha is 250, of which 238 are elected and the remaining 12 are nominated by the President for their special contribution to art, literature, science and social service. And the members of Rajya Sabha are elected for a term of 6 years. Though the Rajya Sabha is a permanent house, 1/3 of the members retire every 2 years. And the elected members of each state legislature elect their representatives on the basis of proportional representation by means of the single transferable vote. And there are no seats reserved for the scheduled castes and scheduled tribes in the Rajya Sabha. The deputy chairman of Rajya Sabha is elected by the members amongst themselves. In the absence of the chairman, deputy chairman presides over the function and proceedings of the house. And UP has largest number of Rajya Sabha seats, 31, and Maharashtra second largest, 19. While any states except Assam has one seat each. Powers and functions with regard to legislative powers, the authority of the Rajya Sabha is co-extensive with that of the Lok Sabha. No measure can become a law unless it has been passed by the Rajya Sabha. It has been passed by the Rajya Sabha. As regards money bills, these cannot be introduced in the Rajya Sabha. When a money bill is passed by the Lok Sabha and sent to the Rajya Sabha, the latter can delay the bill for the 14 days. It cannot reject the bill. Qualifications for the member of Rajya Sabha: the candidate must be a citizen of India, 30 years of age, a resident of the state from which he is taking election. Lok Sabha, the Lok Sabha consists of directly elected representatives. There cannot be more than 530 representatives from the states, 20 from the UTs, and not more than the two nominated members from the Anglo-Indian community, in total 552. At present, there are 545 members in the Lok Sabha, of which 530 are from the states, 13 from the UTs, and 2 nominated by the president. The representation of parliament and its number of 543 has been frozen till 2026. The party with the largest number of members after ruling party and having at least 1/10 of the strength of the Lok Sabha is recognized as a opposition party. The leader of opposition in both the houses of the parliament is entitled to the salary allowances and other facilities equivalent to that of the cabinet minister. And the speaker, who is a presiding officer of the Lok Sabha, is elected by the members amongst themselves. The speaker continues in office even after the dissolution of the Lok Sabha till the newly elected Lok Sabha meets. He decides whether a particular bill is money bill or not, and his decision is final. The speaker does not vote in the first instance but exercises his casting vote only to remove a deadlock. The majority of the total membership can remove speaker after giving 14 days notice. During this time, he does not preside over the meeting. After his removal, he continues in office till his successor takes charge. And the house also elects a deputy speaker who discharges the duties of presiding officer in the speaker's absence. Immediately after Lok Sabha is elected, president appoints a pro team speaker who is the senior most member in the house, and he acts as a speaker till the speaker is elected by the Lok Sabha. And tenure की बात करें तो constitution provides normal tenure of the Lok Sabha to be 5 years. Parliament by 42nd amendment extended it to 6 years, but the 43rd amendment act again restored original tenure of 5 years. And the life of the Lok Sabha can be extended by the parliament beyond the 5 years term when a proclamation of emergency under the article 352 it in force. Qualification to be a member: the candidate must be a citizen of India, not less than 25 years of age, not holding any office of profit under the government session of parliament. The maximum gap between two sessions of the parliament cannot be more than 6 months. It means that parliament should meet at least twice a year. However, there are usually 3 sessions in the year: budget session February to May, monsoon season July to monsoon session July to September, winter session November to December. Joint session can be ordered by the president to consider a particular bill in the question. A bill passed by one house is rejected by the other, and the amendments made by the other house are not acceptable to the house where the bill originated. In case a bill remains pending unpassed for more than 6 months. End of the session's prorogation. The presiding officer speaker declares the house adjourned sine die. When the business of the session is completed within the next few days, the president issues a notification for the prorogation of the session, and the president can also prorogue the house while in the session. Adjournment: this is a short recess within a session of the parliament called by the presiding officer of the house. Its duration may be from a few minutes to a day together. Adjournment sine die: it is a type of break when the house is adjourned by the presiding officer without fixing any date or time of the next meeting, and the adjournment does not bring an end of a session but merely postpones the proceedings. Judiciary: Supreme Court of India. The Supreme Court consists of a chief justice and 30 other judges who are appointed by the president. Appointment of judges: every judge of the Supreme Court is appointed by the president by warrant under his hand and seal after consultation with the such judges of the Supreme Court and of the high courts as the president may consider necessary for the purpose. In case of appointment of a judge other than chief justice, the chief justice of India is to be necessarily consulted. A judge of the Supreme Court remains in the office until he attains the age of 65 years. The chief justice of India gets his salary of Rs 100,000 per month and other judges 90,000 per month. Qualification: a person can be appointed as a judge of the Supreme Court if he has following qualifications. He must be a citizen of India. He has been for at least 5 years a judge of a high court, or has been at least 10 years an advocate of a high court, or 2 or more such courts in succession. He must be, in the opinion of the president, a distinguished jurist. Composition: the Supreme Court is the highest court of the justice in India, and its main functions may be studied under the following heads. Original jurisdiction: the Supreme Court has exclusive jurisdiction in all the disputes between the government of India and one or more states, and between the government of India and any state or states, and between 2 or more states. Advisory jurisdiction: the president may refer to the Supreme Court any question of law or fact of sufficient importance for its opinion, and the president may also refer to the court disputes arising out of any provision of treaty, agreement, covenant, and engagement or sanand. The opinion or so expressed is not binding on the president. Enforcement of fundamental rights: the Supreme Court has been armed with the powers to issue directions or orders or writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of the fundamental rights conferred by the Constitution. Custodian of the Constitution: the authority of the court is further reinforced by the provision that the law declared by the Supreme Court shall be binding on all the courts within the territory of India. Article number 141 हो गया ये. Constitutional functions of the Supreme Court में appellate jurisdiction in matters involving interpretation of the Constitution. Article 132 of the Constitution provides that an appeal shall lie to the Supreme Court from any judgment, decree, or final orders of the high courts in the territory of India if the high court certifies that the case involves substantial question of law as to interpretation of the Constitution. उसके बाद जो next ये है ये the Supreme Court has also been vested with the wide powers in the form of the judicial review and like the Supreme Court of the USA. According to the right of the judicial review, the Supreme Court can declare any law passed by the Parliament unconstitutional on the ground that it contravenes the provisions of the Constitution. Independence of the judiciary, the independence and impartiality of the Supreme Court is the cornerstone of the democracy. High Court appointment of judges. The judge of the High Court is appointed by the President by warrant under his hand and seal after the consultation with the Chief Justice of India, the Governor of the state, and in the case of appointment of a judge other than Chief Justice, the Chief Justice of the High Court concerned. Qualification की बात करें, a person can be appointed as a judge of a High Court provided he has the following qualifications. He is a citizen of India. He has for at least 10 years held a judicial office in the territory of India, and he has been the advocate of a High Court for at least 10 years of 2 or more such courts in the succession. Conditions of service. A judge of a High Court hold office until he attains the age of 62 years. He may be removed from his office in the same manner in which a judge of the Supreme Court is removed. The Chief Justice of High Court gets a salary of Rs 90,000 per month and other judges Rs 80,000 per month. And state executive and legislature की बात करें, so the state executive, the governor appointment. The governor of a state who is the chief executive head of the state is appointed by the president. Only a citizen of India who has completed 35 years of age is eligible for appointment as a governor. He need not be a resident of that state for the appointment as a governor. He holds office during the pleasure of the president subject to this. He holds office for a period of 5 years. He receives a salary of Rs 1,10,000 per month. During president's rule, he runs the administration directly with the help of the advisors appointed by the central government. Powers of the governor. Legislative powers. He summoned, fixes the time and place for the meeting of the legislature. He addresses the meetings of the legislature at the commencement of the session once in a year, and every bill passed by the legislature must have his assent. He has the power to promulgate an ordinance whenever the legislature is not in the session. Executive powers. He appoints chief minister of the state and other ministers on the advice of the chief minister. He also appoints the chairman and members of the state public service commission, and he acts as the agent of the center during an emergency. Financial powers. No money bill can be introduced in the legislative assembly of the state except on the governor's recommendation. Judicial powers. He has the power to grant pardons and suspend, remit or commute the sentences where the offence is under a law relating to the matters within the executive competence of the state. Discretionary powers. He determines whether the government of a state can or cannot be carried or in accordance with the provisions of the constitution. If he feels that it cannot be so carried on, he can make a report to the president under article 356 ka part 1. The governor can reserve a bill or bills passed by the state legislature for the consideration of the president. State council of the ministers. The constitution provides for a council of ministers within a chief minister at its head, and the governor appoints a chief minister and his ministers. Usually all the ministers must be members of the legislature of the state, but sometimes even a non-member may be appointed a minister. In that case, he cannot retain his office for more than 6 months without being a member of the legislature of the state. The council of ministers is collectively responsible to the legislative assembly of the state. State legislature की बात करें, so the state legislature consists of the governor and 1 or 2 houses, or as the case may be. The lower house is known as the legislative assembly Vidhan Sabha, and the upper house is known as the legislative council Vidhan Parishad. The state legislature of Bihar, Jammu and Kashmir, Karnataka, Maharashtra, Uttar Pradesh and Andhra Pradesh have 2 houses each, whereas all other states have only 1 house each in a Vidhan, that is Vidhan Sabha. Legislative assembly की बात करें तो it is a directly elected body on the basis of the adult franchisee. The total number of the members of the assembly shall in no case be more than 500 or less than 60. Like the Lok Sabha, its normal life is 5 years. A candidate for election to the legislative assembly of a state should be a citizen of India, not less than 25 years of age, and not holding an office of profit under the government, and should possess mental and physical health. Legislative council, like the Rajya Sabha, it is a permanent body. 1/3 of its members retire after every 2 years. Its total members should not exceed 1/3 of the members of the state legislative assembly. Its minimum strength is 40. To be eligible for the becoming a member of the legislative council, a person should possess the same qualification as for becoming a member of the legislative assembly. However, in respect of the age, the minimum age has been fixed at 30 years. And distribution of the legislative powers between the union and the states. The Constitution of India makes a division of legislative powers between the union and the states under the 7th schedule. There is a threefold distribution of powers between the union and the states. Union list, it includes 99 subjects over which the parliament has exclusive power of legislation, such as defense, foreign affairs, banking, currency, etc. State list, it comprises 66 items over which the state legislatures have exclusive powers of legislation, example health, agriculture, etc. Concurrent list, it comprises 47 items on which the union and the state legislature both can make laws, that is criminal laws and procedure, marriages, economic, planning and education, etc. Residuary powers, according to the article 248 of the constitution, the residuary powers are vested in the union legislature, that is the parliament has exclusive right to make any law with regard to any matter not specified in the concurrent or the state list. Circumstances under which the parliament may make laws or on a state subject. In normal times, the parliament has power to make laws with respect to any matter included in the state list for a temporary period if the Rajya Sabha declares by a 2/3 majority to do so. During emergency, during the proclamation of emergency or failures of the or failures of the Lok Sabha, failures of the constitutional machinery in a state, the president may assume to himself all or any of the state or any of the executive powers of the state. Article 356 का part 1 and financial relations की बात करें तो duties levied by the union but collected and appropriated by the states as stamp duties. Taxes levied and collected by the union but assigned to the states within which they are leviable as terminal taxes on goods and passengers carried by the railways, sea and air. Taxes levied and collected by the union and distributed between the union and the states as taxes or income other than the agricultural income. Panchayati Raj, it aims at taking democracy to the village level by the delegating substantial powers to the people's organization. It was the main recommendation of the Balwant Rai Mehta committee in order to popularize community development projects and make them more effective. It was inaugurated at Nagaur in Rajasthan on October 2, 1959. Later it was introduced in Andhra Pradesh. Aims and objectives: people's participation in the government for its success. To give shape to the constitutional provisions in Article 40, the Balwant Rai Mehta committee recommended democratic decentralization of the powers to encourage the introduction of the vigorous democratic institutions at the village level. Panchayati Raj aims at the involving the people in development and planning so that dependence on the bureaucracy could be reduced, and the committee recommended the introduction of a three-tier system of Panchayati Raj. The Gram Panchayat at the village level, the Panchayati Samiti at the block is level with the members elected by the Panchayat of the village within the block, and the Jila Parishad at the district level. Gram Sabha, though it is not a tier of the Panchayati Raj system, it has a crucial role in making democratic decentralization complete. It is a general body consisting of all the other voters residing in the jurisdiction of a Gram Panchayat which extends over one village or a group of villages. The Gram Sabha generally meets twice a year. Gram Panchayat is the first tier of the Panchayati Raj. Its members usually varies from 5 to 31. All the members being elected by the members of the Gram Sabha by the secret ballot, and the president of the Gram Panchayat is usually known as the Sarpanch. And Panchayati Samiti की बात करें, so the intermediate tier in the Panchayati Raj is known as the Panchayat Samiti. Panchayat Samiti, it is also known as the Janpad Panchayat or Taluka Panchayat or Anchalik Panchayat, etc. It comprises Sarpanches of the Panchayats ex officio, local MPs, MLAs and MLCs with or without the right to vote, persons representing women, scheduled castes and scheduled tribes who are co-opted and whose membership is reserved, and persons representing municipalities, cooperatives, etc. The chairman of this body is a non-official who is elected by the members of the Samiti. Jila Parishad, the Jila Parishad constitutes the topmost tier of the Panchayati Raj system. It acts as a kind of the link between the rural local government bodies at the lower level like Panchayat Samiti and the state legislature and the parliament. This is reflected in its composition. Jila Parishad usually consists of the president of the Panchayat Samitis in the districts, members of the parliament and members of the state legislature returned from the district, a representative of the cooperative societies, a specified number of representatives of the scheduled castes and scheduled tribes, and some co-opted members. The president of the Parishad is generally elected by the members, and the district development officer or is the chief executive officer or the secretary of the Jila Parishad, and the district officer of the various administrative and development departments and are its non-voting members. In many states, the collector is associated with the Parishad as a non-voting member. The general trend, however, is to exclude the collector altogether, and the term of the Jila Parishad is 5 years. Functions of Gram Panchayat: promotion of agriculture, rural industries, provisions of medical relief, education, primary schools including schools for the scheduled castes and scheduled tribes, maternity, women and child welfare, maintaining common grazing grounds, village roads, tanks and wells, maintenance of the sanitation, execution of the other socio-economic progress. Important commissions and offices की बात करें, so the Finance Commission under Article 280 of the Constitution, provisions has been made for the constitution of a Finance Commission within 2 years of the commencement of the constitution, and thereafter after the expiration of the 5th year. And then उसके बाद जो next है वो है, it is the duty of the commission to make the recommendations to the president as to the distribution of the net proceeds of the taxes which are divisible between the union and the states, and the principles which should govern the grants in aid of the revenues of the state out of the consolidated fund of India. Union Public Service Commission: the Union Public Service Commission UPSC consists of a chairman and 8 other members appointed by the president, and they hold office for a period of 6 years from the date of their appointment. And the following are the main functions of the UPSC: to conduct the examination for the appointment to the services of the union if requested by 2 or more states, to assist those states in the framing and operating the scheme of the joint recruitment for the services for the which candidates possessing special qualifications are required, to serve all or any of the needs of the state, with the approval of the president if requested by the governor of a state, to advise the union government on all the matters relating to the methods of recruitment to the civil services and for the civil posts, suitability of the candidates for such appointments, promotions or transfers, and any claim for the award of pension for any injury sustained by a person while serving under the government of India. Attorney General of India: the Attorney General of India is appointed by the president under Article 76 of the Constitution. A person qualified to be a judge of the Supreme Court is appointed to the post. He is the highest legal advisor of the government of the India and is consulted on all important matters. He also appears in the Supreme Court on the behalf of the government of India to conduct the important cases. The main function of the Attorney General are to advise the union government in the legal matters, to perform such other legal duties which may be assigned to him by the president, and to discharge such other functions conferred on him by or under the constitution or any other law for the time being in force, and in pursuance of his duties the Attorney General has the right of the audience in all the courts in the territory of India. He has the right to speak or take a part in the proceedings in either house of the parliament or in the joint session of the two houses of or any committee of the parliament. He cannot however vote. Comptroller and Auditor General. The Comptroller and Auditor General of India is appointed by the President. His main functions are to bring to account the receipts and expenditure of the union government, except railways, defence services, and such other ministers, the accounts of which are maintained by the departments authorities, and to audit all the expenditures from the revenues of the union and the states, and to audit all the trading, manufacturing, and profit and loss accounts of stores and stocks where the president may have required him to conduct such audit. And the salaries etc. of the Comptroller and Auditor General of India and his staff are charged to the Consolidated Fund of India and are thus non-votable. The Comptroller and Auditor General of India can be removed from his office only after an address of each house of the parliament supported by a majority of the total membership of that house and not less than 2/3 of the members of the house present and voting. And Backward Classes Commission, it was set up under the Backward Classes Commission Act 1993. Its main functions are to make a proper and effective inquiry for the identification of backward classes and to examine the complaints of over inclusion and under the inclusion, to examine the requests for inclusion in the list of backward classes. And Minorities Commission, it was set up in 1978 to safeguard the interests of religious minorities, to preserve the secular traditions, to promote the national integration, and to remove the feeling of the inequality and discrimination among the minorities. National Human Rights Commission, it was established in 1993 and it deals with the complaints of the human rights violations including excesses by the armed forces. National Women Commission, it was set up in 1992. Its main function was to investigate and examine legal safeguards provided for the women under the Constitution of India and others laws, and to recommend the measures of the government of their for their effective implementation. University Grants Commission, it was set up in 1953. Its main functions are to promote and coordinate university education, to determine and maintain standards of teaching, examination, and research in the universities, to inquire into the financial needs of the universities, and to make appropriate grants to different universities, and to advise and the establishments of new universities and other matters pertaining to the higher education. Important constitutional amendments. First amendment जो है 1951 to it permitted reasonable restrictions to be imposed by law on the exercise of the rights of the freedom of speech and expression in the interest of the friendly relations with the foreign states, public order, or incitement to an offense in the relations to the freedom of speech. Seventh Amendment 1956, it purported to give effect to the recommendations of the States Reorganization Commission and necessary consequential changes, and it involved not only the establishments of the new states and alterations in the state boundaries but also the abolition of the three categories of the states and the classification of the certain areas as union territories. 10th Amendment 1961, it provided for the inclusion of the former Portuguese enclaves of Dadra and Nagar Haveli within the India as a union territory and for its administration by the President. And 12th Amendment 1962, it included the areas of Goa, Daman and Diu as a union territory and empowered the president to make the regulations for the peace, progress and good government of these areas. And 13th Amendment 1962, it created Nagaland as a 16th state in the Indian Union in the pursuance of the agreement between the Government of India and the Naga People's Convention. 14th Amendment 1962, by this amendment Pondicherry was made a union territory. It also created legislatures for the Himachal Pradesh, Manipur, Tripura, Goa, Daman and Diu and Pondicherry. 15th Amendment 1963, it increased the age of the retirement of the judges of the high courts and made provisions for the compensatory allowances to the judges who were transferred from one high court to another. It also empowered high courts to issue directions, orders to writs to any government authority, etc. 18th Amendment 1966, it provided for the linguistic reorganization of the Punjab into a Punjabi speaking state called Punjab and Hindi speaking state called Haryana. 21st Amendment 1967, it includes Sindhi language in the 8th schedule of the Constitution. 22nd Amendment 1969, it empowered the Parliament to form a new autonomous state of Meghalaya within the state of Assam. 24th Amendment 1971, it affirmed Parliament's power to amend any part of the Constitution including fundamental rights by amending Article 368 and 13 of the Constitution. 27th Amendment 1971, under this amendment two new union territories Mizoram and Arunachal Pradesh were set up by the reorganization of the state of Assam, and the amendment also enabled a promulgation of the ordinances by the administration of certain union territories. 31st Amendment 1973, it increased the upper limit for the representation of the states in the Lok Sabha from 500 to 525 and decreased the limit for the union territories from 25 to 20, thus increasing the elective strength of the Lok Sabha from 525 to 545. 36th Amendment 1975, it made Sikkim the 22nd state of the Indian Union. 42nd Amendment 1975, 1976, it made a number of important amendments to the constitution, mainly for the purpose of giving effect to the Sovereign Singh Committee report. The main features are: it established beyond doubt the supremacy of the parliament over the other wings of the government. Directive principles were given precedence over the fundamental rights. For the first time, 10 fundamental duties were enumerated, imposed limits on the power and jurisdiction of the judiciary, and the term of the Lok Sabha and Vidhan Sabha was raised from the 5 years to 6 years, and preamble to the constitution was altered from sovereign democratic republic to the sovereign socialist secular democratic republic, and unity of nation into unity and integrity of the nation. Quorum for the Lok Sabha and Vidhan Sabha prescribed in the constitution was removed so that it is not a constitutional necessity, etc. 44th Amendment 1978, the right to property was omitted as a fundamental right and was made only a legal right. It was, however, ensured that the removal of the right to property from that list of the fundamental rights would not affect the right of the minorities to administer educational institutions of their choice. Article 352 of the Constitution was amended to provide the armed rebellion as one of the circumstances for the declaration of the emergency. Internal disturbances not amounting to armed rebellion would not be a ground for the issuance of the proclamation. 52nd Amendment 1985, it provided that a member of the parliament or a state legislature who defects or is expelled from the party which set him up as a candidate in the election, or if an independent member of the House joined a political party after expiry of 6 months from the date on which he took the seat of the House, would be disqualified to remain a member of the House. And the amendment also made suitable provisions with respect to the splits and merger of the political parties. 55th Amendment 1986, it granted statehood to Arunachal Pradesh, which consequently became the 24th state of the Indian Union. And 56th Amendment 1987, it conferred statehood on Goa and formed a new union territory of Daman and Diu. Goa thus became the 25th state of the Indian Union. It was decided that the Legislative Assembly shall consist of not less than 30 members. 61st Amendment 1989, it reduced voting age from 21 years to 18 years to give opportunity to the youth to become part of the political process. 69th Amendment 1991, it made Delhi the national capital territory and provided for a legislative assembly and a council of the ministers for his union territories. 70th Amendment 1992, it provided that the state in Article 54 and 55 would include the national capital territory of Delhi and the union territory of Pondicherry for constituting the electoral college for the election of the president. 71st Amendment 1992, it amended 8th schedule of the constitution to include Konkani, Manipuri and Nepali languages in that schedule. 73rd Amendment 1993, Part 9 relating to the panchayats was inserted in the constitution to provide for the Sabhas constitution of the panchayats at village and other levels, direct elections to all seats, fixing the tenures for 5 years for panchayats and reservation of not less than 1/3 of the seats for the women. 74th Amendment 1993, it provided for the constitution of 3 types of the municipalities, that is Nagar Panchayats for the areas in the transition from a rural area to urban area, municipal councils for the smaller urban areas, and municipal corporations for the larger urban areas. And 79th Amendment 1999, reservation of the seats for the scheduled castes and scheduled tribes as well as for the Anglo-Indians in the Lok Sabha and legislative assemblies was extended for another period of 10 years, that is up to January 26, 2010. 83rd Amendment 2000, it amended Article 243M of the Constitution to provide that no reservation in the panchayats need to be made in the favor of the scheduled castes and scheduled tribes in the Arunachal Pradesh where the whole population is tribal. And 84th Amendment 2001, it created a new states of Chhattisgarh, Jharkhand and Uttarakhand. 85th Amendment 2001, Article 16 ka Part A was amended to provide for the consequential seniority in the case of the promotion by the rule of the reservation for the government servants belonging to the scheduled castes and scheduled tribes. It also provided retrospective effect from the June 20, 1995. 86th Amendment 2002, it provided that the state shall provide free and compulsory education to all the children of the age of 6 to 14 years in such manner as the state may by law determine. It also provided that the state shall endeavour to provide early childhood care and education for all the children until they complete the age of 6 years. And 88th Amendment Act 2003, it provided that the service tax shall be levied by the Government of India and such tax shall be collected and appropriated by the Government of India and the states, and also taxes on the services was put in the union list of the 7th schedule. उसके बाद जो next है वो 91st Amendment 2003, it provided that the number of ministers including the Prime Minister in the Union Council of Ministers shall not exceed 15% of the total number of the members of the Lok Sabha. And 92nd Amendment 2003, it provided for the inclusion of Bodo, Dogri, Maithili and Santhali languages in the 8th schedule of the Constitution. And 93rd Amendment Act 2005 जो है, it provided reservations of the seats for the SCs, STs and OBCs in the private educational institutions. 94th Amendment 2006, it provided the compulsory provisions of the scheduled tribes affairs ministry in the Jharkhand and Chhattisgarh Council of Ministers and abolished necessities of STs affairs ministry ministers in the Council of Ministers in the Bihar. And 95th Amendment 2010, it states that for the word 60 years, the word 70 years shall be substituted under Article 334 of the Constitution. This article has sought to extend the reservation of seats to the SCs and STs in the Lok Sabha and state assemblies by another 10 years, and the time period of 60 years under Article 334 of the Constitution was to lapse on January 25, 2010, and this act extends the reservation beyond January 25, 2010.